Good afternoon and welcome. This is the regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force, called for Tuesday, July 14, 2009 at 4 p.m. and beginning at 4:03 p.m. May we have the roll call, please?
Member Nee.
Here.
Member Nee present. Member Craven Green. Here. Member Craven Green present. Member Johnson excused. Mr. Chair, there is a quorum.
Thank you. Would you read the first item, please? Before we do that, any changes in the agenda? Okay. Please read the first item.
Item number 1 is the approval of June 9, 2009 regular meeting minutes.
Okay. Is there a motion to approve?
I move to approve the minutes.
Chair will second. Is there public discussion on the minutes? Seeing none, public discussion is closed. Any comments? Okay. Roll call, please.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Johnson excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 2 ayes.
Thank you. Would you read the second item, please?
Item number 2 is the continued hearing on the status of the March 24, 2009 Order of Determination of Rita O'Flynn against the Department of Technology.
Okay. If you bear with me, we need to review the order of determination on this. Okay. Is the complainant present? Okay. Would you please approach the microphone, Ms. O'Flynn, and thank you for coming. You have 5 minutes.
Well, I wanted to thank the Sunshine Ordinance Task Force as well as the Department of Technology for all of their efforts to date. I think from the proceedings and communications that have been going back and forth over the past few months, it's been clearly established that I'm entitled to the records I'm seeking, and that there is a means by which the Department of Technology can get records that have been inappropriately deleted by a city employee or department.
Okay, could you bring the microphone closer, please? Thanks.
And San Francisco Administrative Law Code 67.26 states that a department may not charge any fee to cover time and costs incurred in searching for, locating, or collection of records to respond to a public records request. And I respectfully request that this committee issue a finding that the records should be turned over to me.
Okay. Is there anybody here to present facts and evidence in support of the complainant? Okay, seeing none. The respondent? Thank you for coming. You have 5 minutes.
Thank you. Barry Frazier, representing the Department of Technology. I am a little bit at loss for words. I'm not sure exactly. Okay. Department of Technology provided a response as requested by the committee. We provided the information on the cost that we would incur. To the best of our ability, we estimated the cost it would incur to provide the specified emails that Ms. O'Flynn is requesting, and we provided that information to the committee. We got an email response from Ms. O'Flynn providing a couple of options going forward. We cannot provide the raw disks of data, and I think we've gone through this at least 3 times now. We cannot provide the raw disks of data to anyone without reviewing each and every email on the disk for any confidential or otherwise information that's excluded from disclosure under the Public Records Act or Sunshine Ordinance. We understood that the task force had ruled that that we would be able to recover costs for the various time and efforts it would take for us to provide these records. However, we still stand by the fact, our assertion that nothing under the Public Records Act or Sunshine Ordinance requires us to go through the trash of another department to find records that have been deleted under another department's record retention policy. These are not our records. These are another department's records, And we don't have the expertise to determine whether or not these records should have been deleted or not. And that's where it stands. I don't have the code in front of me. I'm not able to tell the citation that Ms. O'Flynn just provided, so I can't really comment on that.
Okay. Thank you. Is there anybody here to present facts and evidence in support of the respondent? Okay, seeing none. Committee? Member Craven? Craven Green?
I do think this is helpful, and I appreciate both Ms. O'Flynn for her persistence and the department for providing this letter and the breakdown. I think the department and the task force has a dispute as to the fact that computer backup tapes are public records. And we'll just move beyond that dispute. And we've also told Ms. O'Flynn a number of times the reason you can't have the disk is because that would turn over attorney-client information, arguably, or personal information that's not subject to disclosure. So that becomes the problem with just handing over the disk that is the pulled backup tape. So I appreciate that. With respect to the cost of the copies, the issue here is really governed by, unfortunately, until and unless the ordinance is amended, 6253.9 of the Public Records Act, which regards extraction of data from electronic records. If these emails were in fact still maintained in someone's email box, you're correct. The city could not charge a requester for the time required to do the keyword searches, to pull the emails out, and to print them and produce them. You can be charged the normal cost for copying, and that is it, but not the time of personnel for searching. However, when you're talking about records that are maintained electronically as to which programming or extraction must be done, so these aren't records that are currently maintained in the operating system of a city employee, that's when 6253.9 kicks in. So that's why we required the department and found the department in violation of the ordinance for failure to work with you under 6253.9 to provide a cost estimate for doing the search, the broad search that you required. So I think right now here we're basically reached an impasse on this one, and the options are as follows. The options are Ms. O'Flynn could say, well, you know what, instead of backups for 5 years between all these people for all those dates, pull up the backup that existed as of X date, because I think the emails existed as of that one date. That way they could pull up one backup, far reduce the time required, and the cost would be substantially less. But in absence of proceeding against the Mayor's Office of Housing, you would be required to bear that cost, and the department would have to have some kind of guarantee or down payment or something before they were required to engage in that, because they don't want to have them left holding the bag when there are fees that are appropriately imposed on the requester, unfortunately. The other issue is you did not bring this against the Mayor's Office of Housing for allegedly improperly deleting emails that were subject to a pending record request. Through that proceeding, if this task force agreed that those records were improperly, if the full task force agrees that the records were improperly deleted or improperly withheld from production, then you could ask the task force to take whatever measures it was to find the Mayor's Office of Housing in violation and have them work with Department of Technology to retrieve the backups at their expense, perhaps. I mean, that's something you could ask. I'm not saying what the full task force would do, but that, as I see it, is your other option going forward, is to bring into this proceeding the party as to whom the costs may be borne because they were the ones who impermissibly deleted these records that were subject to a pending request. But again, I think this is, from our perspective, we have seen email is the issue, not only here, but at the state, the federal governments. These issues are being litigated in many jurisdictions, and it is, in terms of technology, a developing area. And so I really do appreciate having the opportunity to look at this and getting in writing a response from DTIS as to how and what they can do to pull email backups out, because that's something we haven't had before. So this is very useful for future complainants and for the task force to know. Very valuable indeed. So in my perspective, I think, as I said, in terms of what we can do on this narrow matter, we're at an impasse until Ms. O'Flynn makes a decision as what she wants to do to proceed.
Okay.
One other point, I'm sorry.
Please, proceed.
For Mr. Fraser, while under 6253.9, the department is allowed to charge a reasonable fee for the extraction of the data. The 10 hours that you estimated, and this is just for your information, the 10 hours that you estimated for once the email records are identified, responding to the request criteria, printed and reviewed for exempt information and redaction, that is not a permissible charge. That is something the ordinance clearly says you cannot charge staff time for actually, once you have the records, for reviewing them for redaction and production. That's clearly off bounds. So that 10 hours would be not allowed. That was my only other point.
Okay. Ms. Flynn, would you approach the microphone, please? I take it that you did not originally request the records from the Mayor's Office of Housing, is that correct?
I requested them many times.
From the Mayor's Office of Housing?
Yes.
And what was their response?
We don't have them. We're not required to keep them. They were destroyed per our policy.
Okay. Well, I think it's fairly clear. I think Member Craven Green has given you a fairly good explanation as to both of you as to what the options are here going forward and the rights and responsibilities and so forth. So my recommendation is that the two of you kind of get together and see what you can do to move things forward.
I think at this point I'm going to file a formal complaint against the Mayor's Office of Housing. There have been continuing record problems with the Mayor's Office of Housing regarding my property, and I think it's time to bring it to the attention of the city.
Okay.
Thank you.
Is there a motion?
I just think there's no further action required.
Okay, the chair agrees. Is there any public comment on this item? Okay, seeing none, this will conclude then with no action, and I want to thank both of you for taking the time and trouble to come down here. And before you leave, Mr. Fraser, I also want to restate my thanks for alerting us to the existence of the Committee on Information Technology regarding a separate item.
Can I make one statement about that? I just wanted to convey the apologies of the Commission on Information Technology not being able to be here today.
Yeah.
But they will be very, I think, willing to work with you to going forward address some of these issues that really are kind of related to what we talked about today.
Absolutely. Thanks very much. Okay, Mr. Clerk, would you read the next item, please?
The next item is the continued hearing on the status of the April 28, 2009 order of determination of anonymous tenants against the Department of Building Inspection.
Okay, are the complainants here? Thank you for coming. You have 5 minutes.
Thank you. Good afternoon, members of the Compliance Committee, anonymous tenants here. A letter of determination was issued on May 5th, 2009, stating that DBI failed to conduct or provide an itemized cost analysis justifying the $6.50 per page cost as required by Section 67.28 of the Ordinance. On May 12th, 2009, at the Compliance Committee hearing, the committee gave Mr. Strawn an additional 50 days to provide an itemized cost analysis, and Mr. Strawn informed the members that DBI would comply with the order and provide the itemized cost analysis by July 1st, 2009, but he refuses to provide it. According to a copy of DBI's new fee schedule that we received on July 10th, 2009, it states that on June 1st, 2009, DBI removed the $6.50 per page charge. they also changed some of the wording on some of the other fees. The director, Vivian Day of DBI, letter of July 13, 2009 to Sunshine Task Force members stated that effective July 1st, 2009, DBI has eliminated the $6.50 per page charge. Her statement to the members is contradicted to the DBI fee schedule effective date on June 1st, 2009. On July 1st, 2009, DBI should have informed the members and us that they eliminated $6.50 per charge, but they did not. They just failed to contact us or the members at all. Mr. Strachan has stated publicly that they have, I believe, 20,000 microfilm requests a year. And Mr. Strachan has also provided to the members a memorandum dated January 27, 2009, which states DBI receives a total of 11,713 microfilm requests. These microfilm requests produced a total of 106,286 copies of applications, job cards, and CFCs. Now they are trying to play the numbers down of microfilm requests to avoid refunding the overcharges to the public. They say they have very few requests. DBI has charged $6.50 per page for years and continue to charge the $6.50 per page even after Sunshine Ordinance members determined that they violated the law and have failed to comply with the order. DBI has always had full knowledge that the $6.50 per cost per page is an outrageous charge, and now they want to sweep it under the carpet. The public demands that DBI should comply with the order and provide an itemized cost analysis. DBI has violated the laws for years on many things. They've ordered to supply a itemized cost analysis, and you should hold them have them comply to that order.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Good afternoon, members. You already issued the order against the DBI for overcharged, for not providing the itemized cost.
Could you pull the microphone closer, please?
Justifying the
Thank you.
$6.50 per page as required by the law. And on the and then May 12th, in the committee meeting, and then DBI promised that they will provide it by July 1st, 2009. Even though that takes us so many days, so we still patiently waited. Before that July 1st, we asked them, we would like to have a copy. They ignore our request. On July 1st, we have another request, and then they still ignored it. We emailed to Mr. Rustam, and he's nicely enough to tell us that DBI did not provide anything to the board, to the members. Now, while we are here, this is an outstanding order. After the order is issued, they still continue to charge you $6.50 per page. I have been paying for years, $6.50 per page. I'm forced to pay it because I need the public records. Now, I wanted to know why they don't have to comply with the law, and then why they don't have to comply with your order. They should be ordered to provide itemized cost analysis to justify the $6.50 per page. Thank you for your time. I appreciate it.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, respondent?
Good afternoon. William Strawn with the Department of Building Inspection. I believe you received our letter sent yesterday indicating the director, upon evaluating the minimum charge fee, has made the decision to eliminate it. I certainly am not aware that that decision was made to be posted on June 1st. The director told me just yesterday it was effective July 1st. If that is an error, we can certainly get that corrected. But the bottom line was the order of determination, as we understood it, was to provide the detailed cost analysis if we were going to continue charging the minimum $6.50 fee for a 50-cent fee for the specific computer-generated electrostatic charges that were actually part of the building code and approved by the Board of Supervisors in the fee ordinance that was approved as recently as last September when adjustments were made. Those fees are modified periodically. Sometimes they're eliminated, sometimes they're increased. To the complainant's allegations that we have thousands of these, I have actually been told that we have very few instances where $6.50 as a minimum fee have been charged. We can certainly talk to the Records Department about the specifics behind that because I don't have such data at my fingertips today, certainly. But that said, what we had respectfully submitted was that we were not going to post a detailed cost analysis because we were not going to go forward and try to collect that minimum fee anymore.
Okay. Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none. Committee? Member Craven Green?
To Mr. Strong, just to clarify, because it's a little bit ambiguous. You've established the minimum fee of $6.50. What are you charging now for copies of computer-generated electrostatic documents, if anything?
Actually, I don't have any new minimum fee at all. As I don't know what that charge is at the moment. I would have to go to our Records Department to find out.
Right. Well, if it's anything other than 10 cents, then you would need to have a specific justification for it. So
I
if you could,
understood that, yeah.
if you could confirm just by email to us what DBI now is charging for those copies, I would appreciate it.
Right. I'm under the impression we're doing 10 cents photocopy charges, but I will confirm that.
Okay, and Mr. Strawn, if in fact you are continuing to charge more than 10 cents a page, we will still require that the cost analysis, detailed cost analysis, be provided to us.
I understand that.
Okay?
All right. Thank you.
Is there a motion?
I mean, my impression is the order of determination was that they were required to post the itemized cost. However, if they're not going to charge that fee, they don't need to have an itemized cost. So I don't believe we need any further action. But I did want to express my thanks to the anonymous tenants for bringing this issue. I think they've done a great public service to individuals who request records from DBI and in exposing the fact that this fee had not been justified and getting the department essentially to revoke it and make it much more manageable and reasonable for members of the public to get these records. So I think actually that this complaint has been a very big success, and although I don't see a need to do anything further because I don't believe the order of determination requires it, I did want to note that it has been, I think, resolved very successfully through the efforts of the complainants.
Okay. There is apparently no motion to come forth. Is there public comment on this item? No. Okay, seeing none. The respondent and then the complainant, if you wish, has 3 minutes to make any additional closing remarks, rebuttals, explanations, etc. Does the respondent have anything he'd like to add? Okay. Does the complainant have anything he'd like to add?
Tenants here. I didn't make any copies because I wasn't prepared with the last minute notice with the letter. But here's the fee schedule that they posted. Electrostatic reproductions are 15 cents each, effective June 1st, 2009. So Mr. Strong shouldn't be aware of all that this is going on. I mean, it's his department. So he's incorrect in what he had said. So I just wanted to point that out. Thank you.
Okay, how would you reconcile that, sir, with the letter from Vivian Day dated July 13th, in which she said,
All she says is they're not charging the minimum fee. She doesn't say what they're charging.
okay.
I think the question is more appropriate to Mr. Strong.
Mr. Strong, could you approach the microphone, please? What are you charging now? What is your, you've posted a fee schedule, is that correct?
Well, according to what our complainant just said from anonymous tenants, I was not aware that this had been posted effective June 1st, as I said. And when I discussed this matter with the director yesterday, and she signed this letter to send to you, she did not indicate to me that we had posted anything new. We just had a new fee modification done through the Board of Supervisors that the mayor signed on the 16th or 20th of June that will take effect in early August, that we have just started a post as far as making customers aware of that. But I'm not aware that this specific 15 cents rather than 10 cents for the electrostatic charge was posted. I'd be happy to look into that and clarify it via email, as I just said to Member Cravendahl.
Okay, what I'm going to request, sir, well, let me put this out as a suggestion if Member Craven Green would like to comment on it. I would like to suggest that you send to this committee through the administrator the complete fee schedule. Okay, paper copies, electrostatic copies, et cetera, complete fee schedule. And where any fee exceeds 10 cents per page, a detailed itemization of the cost justifying that fee. And then we will continue this matter until our next regular meeting, which I believe would be August 11th.
Very well.
Okay.
I'll do that.
Thank you. I believe that concludes this item. Thank you all for your attendance today. Thank you for taking the time and trouble to be with us.
Thank you.
Okay. Mr. Clerk, could you read the next item?
Item number 4 is developing recommendations for the proposed electronic document retention policy of the Sunshine Ordinance Task Force.
Okay. A few things I'd like to say just to kind of kick things off. Number one, as Mr. Fraser told us a few minutes ago, nobody in the Committee on Information Technology could be with us today. Unfortunate, it would have been, I think, very useful as a way of continuing this discussion. In addition, I received an email communication a little less than a week ago, I believe it was July 9, from Kimo Crossman, in which he reiterated a number of the suggestions that he had made nearly a year ago. And he has voiced some frustration that this is taking so long to move forward. And I have to say in all honesty that I can understand that, and I agree with some of it. But the wheels of government at times move too slowly, and regrettably, that's the way it is. The Committee on Information Technology is not meeting this month, and I will be apprised as to when the next meeting is. So I think that will be a good way of kicking off a working relationship with the COIT and getting from them a sense of what the possibilities and limitations are on email storage and retrieval and backup, particularly as they move forward from converting their system from Lotus Notes to Microsoft Exchange. The chair will note that there is, at this point, nobody in the audience section. Member Craven Green?
Yeah, I know that the email from Mr. Roberts to you sent today, it looks like, suggested that the first step, in his view, would be to meet with the Department of Technology staff, in particular Richard Robertson, who's the Director of Operations, who is leading the new email conversion project. The purpose of this meeting would be to define some of the issues and options. What I would suggest is, because I'm particularly interested in participating in this, and if you are also interested in participating in this, then we need to do it in a public meeting, would be to invite, therefore, Richard Robertson to present to us at the next Compliance and Amendments Committee.
Okay. Sounds good.
And that way we can start the process and as this email suggests, define the purpose, define the issues and options. So if we could do that through the chair.
We will do that. Mr. Rustum, could you please take note of that and make sure that Mr. Robinson is asked to request to come to the next meeting? And you might just also invite the others listed on the email. Mr. Robinson, Mr. Fraser, Mr. Vine, and Mr. Walton, because they might have some valuable input as well. So you might invite all of them, ask all of them to come as their schedules will allow.
I mean, through the chair, I mean, that I leave it up to the chair's discretion on that, but if Mr. Roberts is suggesting that the Director of Operations, who's leading the issue, is the one we should first touch base with, I mean, I guess we could say that we'd want to speak with him, and of course the others are invited as well, but I want to make it clear that we're not requiring the others to come, or
right.
Just because I know their time is limited, and we probably want to meet with those others on more detailed issues later.
That's fine.
So just as long as that's clear that it's Mr. Robinson who we really would like to speak with, and of course others who are interested in weighing in should attend too.
And of course, their comments by email are certainly welcome.
Definitely.
So is it Mr. Roberts you wish, or
Mr. Robinson, Richard Robinson.
Unless I'm reading that incorrectly. Richard Robinson.
Okay. The chair will note that there is nobody in the audience section. So this item is continued till our next regular meeting. And would you read the next item, please?
Item number 5 is a proposal to add to the amendments a provision prescribing disciplinary measures against any attorney in the city attorney's office who knowingly provides erroneous advice to a city official, employee, or entity on an open government-related matter.
Thank you. This is something that This is a germ of an idea I have, and I will explain the rationale behind it. Many times when people refuse to provide a record to a requester, they will argue that they were acting in accordance with advice from the city attorney. There are cases where we have had strong disagreements with the city attorney, particularly in the area of providing electronic records in their native formats. We have consistently held that the formatting is up to the requester to determine, and the city attorney's office has consistently, particularly one city attorney, has consistently said no, that's not the case. And I frankly also have trouble sometimes with the argument that following the city attorney's advice is justifiable. And I'll use an extreme example. If somebody if you've got a grudge against somebody, you want to go out and do them some serious harm, and your attorney say, yeah, I'm telling you as your attorney that it's okay, go for it. And I go out and do it, and I'm arrested, and I go before the judge, and I say, well, my attorney said it's okay. I think the judge is going to, and a jury would hold both my attorney and me liable for the harm to the other person. So it is true, I think, in ordinary circumstances that following the advice attorney constitutes due diligence, but at the same time, when an attorney is consistently giving advice that runs counter to the law, I think that attorney should be held to account for it. So what I want to discuss here is how could the language be drafted? What, if any, penalties should we recommend? This is probably not going to be an easy one to add. There will be lots of back and forth, but I at least wanted to get it out there in the public forum. And I would welcome comments from Member Craven Green, and I would welcome comments from Mr. Laurenti.
I think that the way it's phrased is fraught with problems. Who's going to determine the state of mind of an attorney giving advice to a client agency? And I understand the analogy in the criminal law sense because I was a public defender for 22 years, but it's hard to transfer that thinking where there is, as far as criminal law, it's almost strict liability. You can't rely on the advice of an attorney when he tells you can go ahead and kill somebody, when everyone knows that is inherently wrong. And but in a situation, in a civil sense, where you're talking about public records and disciplinary action is another problem as to who's going to impose discipline, who's going to determine whether there's been a knowing violation in providing erroneous advice. Those are, again, issues that which form is going to determine those things. And then, is it who defends, who prosecutes, who defends the attorney? I just don't know where it would go. I have not consulted with anybody in my office on this issue, and there's a wall, I think, obviously, in this issue right now, and I'd like to hear from other First Amendment attorneys what they might think on this issue. But I see some due process issues here that need to be addressed.
Member Craven Green.
Yeah, I think there's a number of issues that make this particularly problematic. The first one is conflicts with the civil service regulations. If you're talking about imposing discipline on a public employee, there is a whole set of processes by which due process requires those determinations to be made, and they're made through the Civil Service Commission. That there's certain steps and warnings and procedures that for city employees who have tenure, they are protected. So that's a huge problem right there. And in terms that goes to Mr. Laurenti's issue of which venue would be deciding this. The second issue is that there's a real, these are basically similar to civil rights cases that are being, in some ways, tried in the district court or the superior court for the federal civil rights cases, deprivation of a civil right. I'm not saying that entitlement to a public record is a civil right. There's a whole interesting analysis that would have to be done for that, but it's a very complex, my point is it's a very complex and heavily regulated area of when a government employee can be punished for violating the law. And we can see that with respect to the Ethics Commission. That's why in the amendments that's why we refer enforcement proceedings to the Ethics Commission, because that is a forum that has due process, regulations that respect due process and can result in the imposition of discipline or fines. That's why for a violation of the ordinance, that's where it goes, because we don't have the ability at the task force to have those types of due process hearings. So the only place I could see some of this being included would be with respect to the ethics, in Section 4, Article 4, with respect to the Ethics Commission. It would be another section as what the Ethics Commission could do against the city attorney. However, that said, I still think there's a huge problem because the ultimate decision as to whether or not to produce a record is with the city agency or the commission, however you define that. It's not with the city attorney. And there have been instances where the agencies have said, I've been advised by the city attorney that I can withhold this because of X and Y, but I'm not going to withhold it. I'm going to give it out. That's who the liability rests with. It rests with the department who fails to produce the record. So I really have serious concerns about how this could be done and whether it should be done.
Okay. The chair will note that, again, that there is nobody in the audience section. You know, I threw this out because I wanted to kind of get our mental juices flowing on this. And perhaps somewhere down the road more thought could be given to this. But I think in the case of some members of the city attorney staff, it kind of it really, you know, weakens the task force when city attorneys come back, particularly on the electronic records format issue, and give advice that is clearly counter to both the ordinance and the California Public Records Act. I think there needs to be some way to hold them to account, and I think Mr. Loretti's suggestion that we perhaps consult with some attorneys familiar with sunshine law is a good one. So I think I will pursue that. Mr. Loretti?
There are two prongs. This was one where you're trying to figure out a way to I don't know what the word is, go after certain deputy city attorneys who are giving advice which, in your opinion or in your rulings, has been counter to what you've decided. But then, Member Craven has also talked about the client agencies, the responding agencies, who receives advice, but from their own policy perspective, decides to either keep it or to release it. And we're now in a stage with this changeover to a new format in terms of electronic messaging, where there's some policy that's going to be made here. And it's going to be interesting to see how that plays out. And that policy that's developed may obviate the need for the city attorney to give advice about whether or not to produce it or not, because the policy is going to generate the position as far as whether it's to be released or not. I mean, and I think that there's some positive ways in which you could input that in order to get what you want. I'm not sure using this approach is going to get anything but probably lack of cooperation, if that's the word from my office. I mean, it's just, yeah. I think what we want to do is we want to get compliance from the client agencies. That's where the challenge is, and I think that we have a new open approach in terms of approaching these agencies directly in trying to get some compliance, irrespective of what my office has advised. You know, certain deputy city attorneys have advised.
I mean, the issue is you ask how to hold them responsible. You hold attorneys responsible by suing their client and by, I mean, that traditionally you you sue the client. Someone asks for electronic records in native file format. The city says no. If I weren't on this task force, I would take that case in a heartbeat and file it in Superior Court on behalf of the requester against the city department who refused it. The city department seeking a release of that record and injunctive declaratory relief that the city shall comply with that provision. And if the city was unwise enough to litigate it and it went to judgment and the client won, my client won, the city's on the hook for paying my attorney's fees on an issue which they should have known better. So I mean, that's how it's traditionally done.
Yeah. And then the client agency doesn't use the city attorney's office from that point because it's not cost effective to go that route.
Well, but not everybody can afford to go to court on such things, and
certainly
they depend on us to to rule in their favor and to defend their rights, to uphold their rights under Sunshine. So,
right. But I mean, that's the same issue as the enforcement. I mean, that's the inherent issue of why this task force doesn't have the enforcement powers. I mean, that's the problem. Mm-hmm. It's the same problem.
Right. If you're an advocacy group, it's hard to be the judging group too at the same time. If you're pushing forward openness and sunshine, trying to get to the legislature, the board of supervisors to move forward on that issue, to identify issues as you have, make recommendations as far as compliance, and moving it towards enforcement.
Right.
It's hard to say, okay, now I'm going to switch hats quickly, and I'm going to find you,
right.
I'm going to now penalize you. So there,
I mean, if you're the Securities and Exchange Commission and you want to sue someone for insider trading, and their defense is I relied on my attorney, and you see this attorney around town a lot, and you're like, that person is just giving bad advice. The way you go after them is you go after the client. I mean, that's just that's what you do to enforce the law.
Mm-hmm. Okay. One other thing. It's possible that I could have saved, I guess, a little time at today's meeting by throwing this out in communications to Mr. Laurenti and perhaps to Member Craven Green, but that would have violated the Brown Act and the Sunshine Ordinance. So I did want to get this out here in public, and I'm not an attorney, and certainly the opinions that the two of you have are going to carry a discussion like this much more weight than mine. So I think that pretty much wraps it up, at least at this point.
There's no harm in discussing ideas, and it
we
should
should
be done
not
in a
feel
public
constrained to want to voice an idea and have it vetted.
Exactly.
Because that's how it's tested, so we can see where it has traction or not. I mean, and it's good to discuss things, even things where you're attacking my office. That's.
Well, Mr. Laurenti and I could be wrong. I mean, Mr. Frank from Californians Aware may have a different, opinion on it, and certainly you should seek that out. It's just that's certainly, I think, my gut reaction.
Well, I think there are some excellent points that both of you have raised, though. Particularly if we tried to go after a member of the city attorney's office, who would make the kind of determinations that need to be made? Who is to determine the attorney's state of mind as to what was the attorney's state of mind at the time that attorney gave the advice? So there are all kinds of questions and ramifications in this, but I think it will be interesting to see what people like Terry Frank and some of the other FOI attorneys say. And at this point, I don't see any need to continue the discussion or anything like that. So I think that takes us then to item number 6, Mr. Clerk.
Item number 6 is the continued discussion of the proposed amendments to the Sunshine Ordinance.
Okay. since Member Craven Green drafted the footnotes, did a very thorough job, for which she is to be thanked, I will let her start off the discussion.
Well, I think that I guess my first question is, did we have any comments or additions to the annotations from members of the task force or members of the public? I see what we have from members of the public, but I'm asking about questions to the annotations.
Okay. I do have some brief comments. Some of these are pretty piddling. Some of them have to do with the text in the language of the ordinance itself.
Well, I think that they're different issues. I think we should address them differently, because we here on the committee can make changes to the annotations. Those are a work in progress. They haven't been voted on or approved by the task force. So,
right.
And the issue with the broader issue is to which the comments, the very helpful comments supplied by Alan Grossman and by Martin McIntyre, I think, well, he had some typographical ones. Those are different. Those are substantive changes, as to which I have some suggested substantive changes as well.
Okay. I jotted down some questions that I have here, and some of them may be a result more of my own lack of perspicacity than of anything, any errors of omission or commission by Member Craven Green. First, on page 6, footnote 3. I don't know if this really matters, but there are no articles in there, A, N, and the. Adding those may or may not clarify what the footnote is intended to say.
I'm sure. What can you do that again?
This is page 6, footnote 3. There's no. This is footnote 3. Yeah, footnote 3. Revised to clarify ambiguity regarding advisory committees and bodies, make clear that where body as opposed to the body is tasked with changing or implementing new policy.
Did you want to put an and in?
I would say where a body is tasked with changing or implementing new policy. They are policy bodies, all bodies created by the mayor, except ones that include city employees to meet with residents are now policy bodies. Yeah, just those two insertions. Okay. Let's see. Page 7, footnote 4. See above, expanded category of policy bodies. Above where? I'm really not sure which part of the above we're supposed to look at. And maybe again, maybe this is just something that I missed, but it's not entirely clear to me.
It would be in, let's see, it would mean basically it's footnote 3 explains the changes to C, passive meeting bodies, and D, policy bodies. And so it explains why policy bodies have been expanded. So it's seeing above footnote 3 for the explanation.
Okay.
We could just say see above footnote 3.
Yeah, that works. Okay, and then let's see. Page 16, footnote 19. Again, this is a small one. I believe, let's see. Revised consultation with mayors to provide that for all board. First line, all boards should be plural. And commissions. That's it.
In charter, comma, agendas and all materials will be made available. Yeah, there needs to be a comma there too because it doesn't read right.
Okay. Let's see. Pages 19 through 21. There is a lot of text deleted, and I don't see any notation.
It's on 20. It's page 18, 21.
Pages 19 through 21.
Right, and the explanation of why it's deleted is on 18.
Oh.
Note 21.
Okay.
Basically, we removed all that because it was duplicative of the Brown Act and we didn't need it.
Okay.
What we kept were provisions that go beyond the Brown Act.
Page 23, footnote 23. The provisions of this section have been moved. Where?
If you look, the subsequent footnotes note where they were moved.
I'm sorry?
The subsequent footnotes.
Mm-hmm.
So A, it says revised and moved to new 6714 BC.
Okay.
And 25 is the first line of former B. That was moved to section 67.8A. And the second sentence of former B was moved to 6712E.
Okay. All right.
And we could just say, I tried to do it because the whole section looks like it's gone, but it's not. That's why I put it in a separate one, as opposed to saying.
Okay. Page 73, footnote 36.
There's nothing in between? There must be. There must be.
Not that I detected.
Well, I need to read it again more closely. I bet there are.
That may have been the period of my somnambulance, but anyway, just this is a grammatical thing. Creates new provision. I don't think we need the word "new" there.
Okay.
And then there are some. Page 73.
Footnote 36.
Footnote 36. Cross out the word "new." Delete the word "new."
Mm-hmm.
Let's see. There was something in the text, too, that I think needs fixing. Okay, page 34, line 6.
Sorry, which is that page?
Page 34, line 6. I believe that what we wanted to do was replace one phrase with another. Replace San Francisco residents with members of the public.
Correct.
Here they're both underlined. So I believe San Francisco residents should be strike-through type and members of the public should remain underlined.
Well, that we'll have to see. I have a list of things that I gave to Frank Darby that needed to be followed up on. He spent a huge amount of time doing this manual strike through, and then when I reviewed it, I saw things that like this that looked like they weren't correct or that there had been a mistake, and so I had sent him a list of things to be looked into, and I'm not sure if he has had the opportunity to do that. I followed up with another. I sent that about 6 weeks ago. I followed up with an email a couple weeks ago and haven't heard back. So I will add this to the list of things that Frank Darby should look at.
Okay.
To
clear up.
Clear up.
Yeah. Okay.
Yeah.
And also in page 26, line 1, where there's a reference to the Attorney General. I believe that should stipulate State Attorney General.
Well, it sounds like something we might need to add.
Page 26, line 1.
But that's a potential addition. So that should be, as opposed to just a clarification. let me put this in. I'm keeping track of other additions that we may want to do.
That's, for the footnoting, that's what I have. There are some other substantive suggestions that I'll have, but those are for another time. And again, thanks to Member Craven Green for her diligent and outstanding work in this project.
No problem. I think what we need to do now, through the chair, is look more broadly at, take this opportunity to step back and say, what have we missed? There were some typographical things, and this is with respect to the substance of the amendments. There's some typographical issues that need to be cleared up. I don't think those will be controversial, but we need to track those and start preparing a document that takes basically the good work that Frank did, and then set that document aside, and then make additional changes, perhaps in double strike through or some other way that we know it's a new change, to address not only the typographical but also the substantive issues. Like, for example, one thing we did not clarify is we've held that people acting with the authority of the department head can create a passive meeting body. Departments have come before us and said, well, this body wasn't created by the department head, which is what the statute reads, therefore it's not a passive meeting body. And we've said, no, the intent is to capture basically, whether it's the deputy head or whether it's the head of a section, any body that's basically meeting to perform the functions of a passive meeting body is a passive meeting body because they're acting with the authority of the department head. That's consistent. I think Mr. Laurentian would agree. That's basically what we've held. So I think at this we should take this opportunity to clarify that. That hasn't been done. Mr. Grossman provided a very helpful list of additional changes, some of which I disagree with and some of which I agree with. That was very helpful in general. I'd like the opportunity to take the ones that I agree with and make suggestions, and then have a situation where we go through each of his suggestions and say, what does the committee think of this? What does the committee think of that? There's also have been suggestions that Kimo Crossman has made, that many of which we looked at and rejected, some of which we may not have given enough time to look at and we may want to accept. I know that we did accept many of his and we rejected many of his. But I think that needs to be done again as well. And as I said, I have a list that I've been keeping while making the amendments. I would see things and say, oh, that's ambiguous, or that didn't clarify, or, that's been a subject of 10 complaints and we haven't addressed it in the ordinance. So what I think we should do at the next meeting is have this on schedule again. I will make the changes to the annotations that you've identified, and if there were any other suggestions from any other members, which I don't think we've received, I would happily make those. And then, you and I and the other members of this committee should say, what have we missed? Here are some things that we've missed that I'd like to propose making it, another change, because I think there are some substantive things that we haven't done that we should do before we put it forward. So what I will do is I will, before the next meeting, is edit those comments or edit the annotations, make sure there's nothing I want to add to the annotations, do that. But with respect to the text, that's where we have to be careful. Make suggestions to further additions to the task and do that in a way that makes it clear that these are ones that have not been approved by the full task force. So I will commit to doing that by the next Compliance and Amendments Committee, and if Member Nee could do it and other folks as well, I think that would be helpful, because there are some significant issues that are out there, and I did find Mr. Grossman's comments a few of them I very much agree with, like defining agencies and departments and having a consistent definition, because we use them interchangeably and it causes confusion throughout the ordinance. So, I mean, there's certain things that I think we should do that we haven't done. So I would ask to continue this, to have a substantive, and I'm talking like back in the days of old, 2-hour discussion about what about this change? Should we move for that change, and schedule that for the next meeting so we can make some headway on this and move forward expeditiously as possible.
Okay. Mr. Rustam, are you with us on that? Okay, so you can calendar this for the next meeting as a continued item. A couple of comments. I was equally impressed with the suggestions from Mr. Grossman. I was particularly intrigued with one of the things he said early on, which is removing the ordinance from the administrative code and declaring it a law separate and equal with both the administrative code and the charter. I think that I'm not sure what the legal ramifications are on that, whether it's legally doable, but one of the issues that we've been up against is whether the Sunshine Ordinance has equal weight with the charter. Particularly in light of I forget which section it is, but it basically declares that the ordinance has precedence over other local laws when it comes to sunshine. As a matter of fact, I queried a number of the FOI attorneys on this very matter, and what came back to me, I asked them, does the ordinance carry equal weight with the city charter? And they gave me back kind of a multi-part answer. In terms of just a straight yes and no, the charter is the prime body of law in the city, and it does take precedence. However, the charter does not take precedence over state law. So if you have a provision in the charter that, say, has less sunshine in it than the Brown Act or the California Public Records Act, then those laws, those statutes would have primacy. So that's an interesting question. And
well, that exists as it is now. The real question is, can you, pursuant to state law, which provides that you have the ability to establish higher thresholds for public records and open meetings than the state law does, enacting a law through that mechanism, can you thereby circumvent the charter? I mean, that's a very technical question, and that's really kind of the open area, as I understand from these same folks. But I agree, Mr. Grossman, with all due respect. Actually, I shouldn't say that phrase because that's a terrible phrase to use. But I appreciate Mr. Grossman's opinion on these issues. I disagree with it, but I appreciate it. I think perhaps there are things that we can do to make sunshine equal with the charter, but they would require charter amendments. I don't think we can do it by simply amending the ordinance. Or changing the name, or putting it in its own separate section of the municipal code. I think the only way to do that is by charter amendment.
Okay. One other thing.
But I appreciate the discussion.
Yeah. One other thing that I want to mention, when I was elected task force chairman at the last task force meeting, a number of members indicated to me verbally that they are interested in serving on this committee. And I think that it's reasonable to expect that I will be expanding this committee to 5 members, starting with our next meeting.
As the chair of the full task force, what is your plan?
I do intend to remain on this committee, yes.
Okay.
Some people have encouraged me to do so, and I appreciate the votes of confidence that I have received on this, and the areas that we're going through now, particularly with amending the ordinance. This is kind of a critical juncture, and I have every intention of continuing on this committee. But again, there have been a number of other people who are very interested in joining it, and I want to accommodate them too. I think that takes us to public comment on non-agended items, and the chair will note that there is nobody in the audience section, so item 8 is closed. I believe that takes us to item number 7.
Item number 7 is the administrator's report. Mr. Chair, we have 3 complaints come in.
Okay.
I'll be sending those out tomorrow, and we do not know where it'll end up. So that's in the pipeline.
Okay.
That completes my report.
8 complaints to be heard at the full task force.
8 complaints to be heard
Glad
at
I'm
the full task
missing
force?
that meeting.
That's
8 complaints plus 2 others, I think,
that will be at the next task force meeting?
on the 28th.
Okay, and that's 8 plus 2, what now? 8 complaints.
8
Plus
complaints.
2 is 10.
Oh, 2 continue.
Two continue,
So we
yes.
got 10. Bring sleeping bags and a snack. Okay. There is no public comment. Any comment from the committee on the administrator's report? Okay. That takes us to item 9, announcements, questions, etc. Member Craven Green?
Yeah.
Mr. Laurenti? Mr. Rustum?
I do not have
Okay, I just have one brief announcement. I've some good news regarding our friend Joe Lynn, the former ethics commissioner. He is out of the hospital and in good health.
Right.
Chair will entertain a motion to adjourn.